Ladies and gentlemen, Ranveer Allahbadia has got the tongue lashing of his life from India's top court. Perverted, depraved, dirty-minded. These are just some of the words that the Supreme Court used to describe Allahbadia today. A bench of Justice Suryakant and Justice N. Kotiswar Singh convened to hear Ranveer Allahbadia's plea to club all FIRs against him and seek anticipatory bail against a possible arrest. Allahbadia was being defended by Abhinav Chandrachud, the son of the former Chief Justice of India, D.Y. Chandrachud. The bench strongly criticized Ranveer Allahbadia, calling him a pervert for his offensive language. The court stated that his remarks have not only embarrassed his family, but also left parents, sisters, and society at large appalled. The bench even added that such behavior reveals something deeply disturbing in his mind, questioning if there could be any clearer example of obscenity. Now, after this verbal tongue lashing, the court did grant Allahbadia protection from arrest, but with several riders. Allahbadia is now required to join the investigation as and when summoned and fully cooperate with the ongoing probe. Additionally, Allahbadia has to deposit his passport at the Thane police station and seek permission from the Supreme Court before leaving the country. He and Samay Raina are also prohibited from airing any other show or content until further orders are issued. So, in effect, he is still very much at the mercy of the state. But ladies and gentlemen, the true repercussions of today's order will be felt far beyond just the oral observations over a podcaster's crass comedy. The Supreme Court has urged the government to step in and regulate content that is being put out by influencers on YouTube. Now, ladies and gentlemen, sounds good, but this can open a can of worms because it paves the way to revisit the 2024 scrapped Broadcasters Bill, which had been criticized for suggesting curbs even on digital content creators. The bill, which is thankfully in cold storage at the moment, seeks to look at content creators as digital broadcasters who will have to be registered under the government and will therefore have to be, well, kind to the government to survive. Essentially, no jokes or criticism against the government. The question to now ask is twofold. Can online content creators now prove that they are capable of self-regulation, or is it too late? And if indeed the government gets to step in, can it be trusted to draw the line between policing vulgar, obscene content and becoming a net nanny against content it wants to censor? That's the debate this evening as well. For the moment, I'm starting with Priyanka Chaturvedi, who is part of the Parliamentary panel on IT, on information and technology, a panel that at one point had wanted to summon Ranveer Allahbadia and Samay Raina. Priyanka Chaturvedi, thank you very much for your time. As someone who's part of the Parliamentary Standing Committee on IT, can I ask you what your view is on what the Supreme Court has said today and why you put out the tweet that you did?
So, two things. Ever since I said that I would be raising this issue in the Standing Committee, as a member of the Standing Committee, which is chaired by Shri Nishikant Dubey, I think it is well within my purview and within my rights to raise an issue in terms of policy, self-regulation, and the content which is out there, and our intermediary platforms such as YouTube getting away with a lot of content which could be deemed even unconstitutional or crossing the boundaries of what is your right versus responsibility. So I was speaking from that perspective, but I did realize, and the FIR was already lodged in Maharashtra by the Chief Minister of Maharashtra, Devendra Fadnavis, followed by Himanta Biswa much later. Now we see even Rajasthan getting in. My idea was not about creating FIRs or filing FIRs. My idea was to, should we discuss this policy loophole or implementation of self-regulation as we want it to be? I'm totally for freedom of speech, but we do not want state intervention. But if people do not self-regulate the kind of content that is there. So that is what I had raised, but I saw a whole lot of trolling happening, especially on Instagram, where perhaps there are these influencers who are very popular with the younger lot. are present in bigger numbers, larger numbers on Instagram. And I have them coming and telling me that there are certain more important issues. There are more issues that need to be prioritized. Why are you talking about it? And the kind of language that was being used was absolutely unparliamentary. Then, of course, there was an entire paid. You can make out, right, after you're on social media, you understand that this is entirely paid campaign. So that was happening too. So when the Supreme Court today made its comments, and again, please understand that the Supreme Court's comments also come out of the same freedom of speech with certain restrictions and understanding what self-regulation is. And there could be some comments which were made, which we can debate whether was in good taste, not good taste, whatever, coming from the Supreme Court. However, Supreme Court had an observation to make. So I was just saying that in case you all found me talking about a policy loophole as a problem and trolling me, then you must hear what the Supreme Court thinks about this particular issue. And I think restraint is very important, and understanding the responsibility that comes with these young influencers is a lot more because they're influencing young minds.
Priyanka, the Supreme Court has told the government either you step in or we will. Is it your case then that the government should step in, because that then will involve the government becoming a super censor and muting anything it wants to via the broadcasters bill, which for the moment it's scrapped, but for all you know, it could be revisited in the context of what has happened?
The net cannot be censored by the very nature of how internet functions. It cannot be censored. But we must understand that there are laws in place too. There are laws such as if you breach that entire restrictions that freedom of speech gives you, then you're perhaps going to face law and the consequences of it, which probably Ranveer is just one of the cases. But India's Got Latent, or India Got Latent, whatever the show is called, is just an example of a lot of such, content out there on social media or internet, etc. It's about taking ownership. So if you're taking ownership of your content, if you're making money out of that ownership, then you must be held accountable for what you're putting out there. That is my point. No, state cannot step in until and unless and state ideally should not step in until and unless people do not flout these norms. And also, we must understand how these algorithm feature works on these intermediary platforms. This is the more controversy you create, the more eyeballs, the more clicks that you get. You go up the chain of the revenue money that you're earning. Who decides the revenue model? This algorithm. Who controls this algorithm? These platforms. So basically, you are paying people to grab more eyeballs, bring them more to your, by clickbait coming to your site, and earn more revenue for it. And they don't hold any moral authority about it. They say, we are just content creators. We are just a platform. So my point is much larger about holding accountability. It's not about introducing new laws. It's about implementation of what is already in place.
Priyanka, for the last 2 weeks, we have seen multiple FIRs, including an FIR in Assam, of all places. 50 people, including Allahbadia and Samay Raina, have been booked as well. You know, the point is, ye kuch zyada nahi ho raha? Is this, in your view, an overreach? Because in my view, it is an overreach. What he did was wrong. What he said was stupid. But to have FIRs registered against you in Bombay and Assam and have multiple people just come and attack you and your family, isn't that an overreach?
I totally agree that there are two things that have happened. Every state competing with each other to file an FIR. So there's been a bit of an, over enthusiasm to hold somebody accountable. At the same time, totally turning a blind eye to various such platforms which are creating this content. A lot of apps, I'll tell you, and I'll give you another example. Information Broadcasting Ministry had pulled down 17 odd apps because they were violating the code of conduct in terms of what should be broadcasted on these platforms, on app platforms. They were putting out semi-porn stuff, which was, again, not censored, which was above 18 content, but people could log in, could download these apps and view such stuff, which leads to, and I tell you, there's a direct correlation to how women are treated in society. If you're looking at women as only sex objects or women in a certain role, it leads to definite consequences for women and children in the society. But one particular app, which is the Alt Balaji app, was kept away from it. Again, my point was, why was selective treatment given to one and not applied to all? So now we have selected Ranveer Allahbadia to take the fall, but the rest of the apps which are content which is proliferating should also be brought under the purview. So filing FIR, every state competing to file an FIR, then threat calls, etc., is an overreach, which should not have happened in a mature democracy. If an FIR is filed and the Supreme Court has taken cognizance, Supreme Court has said what it has, then let law take its own course and lead to where it has to lead. Also, whatever laws that have been applied as to what has been violated, those are all bailable options, all bailable. So that also is something that we need to keep in mind. Law will take its own course, but an overreach and overreaction is certainly not how it should function.
Okay, so then will it also be called an overreaction when the parliamentary panel says they are going to be summoning Ranveer Allahbadia and Samay Raina as well? Because that's what reports have said.
No, not at all. That's absolutely a wrong information. All we have, since the meeting is confidential in nature, but whatever has been done has to do with regards to the IT ministry, to the information and broadcasting ministry, not these individuals, not these content creators. We are not their enemies. Please understand, we are trying to work in a way that kind of streamlines how we generate content, and India could be a very good content could create very dynamically to India's economy. We also understand that the creators economy is something and content creators economy is something that even the Prime Minister has been speaking about, even if I disagree with him on a lot of things, but this is one of the profiles that can lead to revenue generation. But revenue generation has to come with ethical practices, right? Even corporate companies have ethical practices. Even small companies, MSMEs, need to adhere to ethical practices. Even broadcast companies, even media companies, even print companies have to follow some code of conduct or code of ethics. And the same goes for radio as well. Not everything is as per, okay, my mind says it, so I will put it out there and let my people get influenced. And I'm not responsible for the society I live in. I'm not responsible for creating responsible content. So that is what it is about. Streamlining the procedure, not bringing in more laws, not summoning people, not trying to criminalize them, not trying to isolate them into believing that they're guilty, but finding a solution to it for all sides to be able to understand, to thrive, to grow with boundaries in place.
All right, Priyanka Chaturvedi, thank you very much for your time here on Mirror Now. That was Priyanka Chaturvedi, one of the members of the Parliamentary Standing Committee on IT. Thank you very much for your time, Priyanka. My guest this evening, Apar Gupta, is an advocate. He's the co-founder of Internet Freedom Foundation, joining us on the broadcast. Hi, thank you very much, Apar. Karan Verma is an author, joins us on the broadcast as well. Satyam Surana, back on the show with us, is a complainant in the case. Hi, Satyam, thank you very much. And Aba Singh is a lawyer. She's also an activist, joining us on the broadcast. Abaji, thank you very much. I'm going to start with Apar Gupta. Apar Gupta, we'll talk about the tongue lashing that Ranveer Allahbadia has got. There are many people on social media who are saying, what business is it of this, of the Supreme Court of India to give a moral lecture to anyone? But that is a separate debate. I want to ask you what the bigger worry for you is right now with what the Supreme Court has said. The Supreme Court is telling the government essentially, either you step and do something, regulate content, or we will. Is that a worry, and why is that a worry?
I think that would be reading a little too much in the oral observations of the court. I think this is an outcome of the moral panic of what we have been seeing on nightly television debate shows, statements by 2 chief ministers, criminal prosecutions by 3 different police departments, summons issued by the National Commission for Women and 2 separate state-based bodies. It is almost as if the unthinkable has happened. This is something which should not have happened to such a grave degree that the full weight of the government, I would say the entire state, has been activated over a vulgar joke. There's no doubt it's a vulgar joke. But let's look at the proportionality of the response. So what is my deeper worry, and now I can answer it, does not emerge from an observation of the Supreme Court. It emerges from what is a overall sense of moral panic which is emerging. And I was also at the benefit of this hearing Priyanka ji and how she was outlining what is behind this concern of also a standing committee of parliament. Why is everyone in a furore? And I would say that it is because there is now an environment which is conducive to the reintroduction of a broadcasting bill, which only till a few months back was being seen as an attempt by the government to license YouTubers who were critical of it and had found space and audience to be critical of the Prime Minister or the ruling regime. So I'll stop here.
Okay. You'll stop here and I'll let Karan then come in to give us the other side. Karan, that is the worry. All right, the Supreme Court has given a tongue lashing to Ranveer Allahbadia. They've given him some relief as well. There will be no arrests. He, of course, cannot travel outside the country or put out any content. But at least, you know, all the FIRs have been clubbed and there will be no arrests. So I'm sure that is a relief for him. But Karan Verma, come in here. You know, to many people who are watching this story unfold, many people have said this is an overreach. This is, Apar Gupta is saying this is, you know, panicking. We are panicking. This is moral panic that is taking place. But Karan Verma, I want to ask you, is this now the opportunity that the government of India is going to use to bring the broadcasters bill in? Because the court today has said do something. So the government has the perfect bahana to do something, which is reintroduce the broadcasters bill, which, by the way, can be very dangerous.
So, Shreya, I don't see it as a bahana. I see it as the need of the hour, at least to regulate obscenity. You know, if we just stick to obscenity rather than being critical of the government and other views, we can discuss that. But, you know, just to stick to this topic, obscenity has always been illegal. I mean, there are sections under the law, 294, 296, where it is punishable. Section 67 of the IT Act. But what has been the, growing concern is how to define obscenity. And we've had different tests regarding that. We've had the Hicklin's test, which talked about individual susceptibility. From there, we graduated to the Avik Sarkar versus State of Bengal, where we had community standards. But these need to be defined and codified, and there has to be some sort of regulation. Otherwise, you know, people will start saying, oh, it's subjective. What is offensive? What is not offensive? What is offensive and vulgar to you is not offensive and vulgar to me. So we have to have certain guidelines. Otherwise, we'll have more such cases of daylight obscenity going on in our society. So this needs to be curbed. I agree with you on the fact that as a society, maybe certain people may have overreacted. This doesn't need to go to the parliamentary panel. We don't need so many FIRs. I'm fine. But it must be addressed that this was downright obscene. I mean, this was black and white obscene. Certain things, like when you go along themes like incest and pedophilia and other such themes, it is clear that it is obscene. So at least when it's obscene, it's the time to step in and come up with certain guidelines and a bill that regulates it, not censors it, but for sure regulation is important. Otherwise, we'll have more such cases coming up every day. And what is the point of discourses like these, like we are having on your channel and others, if we can't come up with a certain sort of regulatory mechanism? I think that's the need of the hour.
Apar Gupta, the logic is, and this is the logic I've heard from others who bat for the broadcasting bill, is that this is not censorship we are talking about. This is regulation we are talking about. When you have a tool like the broadcasting bill in the hand of the government, please tell us whether it's a tool to censor or a tool to regulate.
I think that logic does not stand scrutiny because firstly, I think the answer also which we just heard from the other panelist was that there is an offense of obscenity, which is a pre-existing offense. And that offense, in fact, in this instance case, has led to the criminal prosecutions, not only of Ranveer Allahbadia or Samay Raina, but even the 40 people in the audience or the other contestants. So it does seem the law is fairly strong. It does seem that the law sets a very strong deterrence. However, I think what is the desire is towards policing and imposing a certain kind of content format where every instance of vulgarity is obscenity. These are two different words. One is vulgarity, the other word is obscenity. And the Supreme Court, and just following the contemporary standards test in Avik Sarkar, only last year in Apurva Arora versus Government of NCT of Delhi, which concerned an OTT show called College Romance, where language was coarse, distasteful, unpalatable, uncivil, improper. In fact, cuss words were used. The Supreme Court quashed those criminal complaints, stating that it needs to be viewed rather from the point of view of we do not like this language to whether this language in a light-hearted OTT series itself is illegal in itself, because the test of obscenity is not bad language. The test of obscenity is sexual arousal, which thereby, in a Victorian sense, depraves the minds of the viewers. So these are two very different things, using coarse language and using a picture or words which cause arousal. The one small thing just I want to add before I end is that, secondly, if you look at the regulatory ambit of takedowns, the show India Got Latent was blocked within hours of the social media outrage. And this was as per a notice. So it's not as if both in terms of criminal prosecution or blocking this kind of content, the government doesn't have the power.
Yeah, so if you already have the power, then why even talk about the broadcasting bill coming back? I think that is the point you're making. Let me quickly get in the two lawyers on the show as well. Satyam Surana, you are one of the complainants in the case. What do you make of what the Supreme Court has said and done today? There are many people on social media, on the internet saying this was a moral lecture. And is the Supreme Court of India a place that needs to dole out moral lectures to YouTubers?
Hi Shreya, thank you for having me back on the show. See, whatever the Supreme Court has said today, they are the statements that have been passed by the honorable judges of the Supreme Courts during the due course of hearing. Without prejudice to the rights of the accused, these statements are not a part of the Supreme Court's order. These statements are a part of the procedures that that took place during the hearing. But these statements purely reflect the feelings of every common Indian. We have to understand that the judge who was sitting on the dais is also a father. He is also a parent. These statements reflect the Supreme Court is the custodian of the rights of the Indian citizens. The Supreme Court is a speaker when it comes it is the ultimate authority when it comes to deriving the interpretations of the basic fundamental principles of law. So when it comes to freedom of expression, when it comes to obscenity, it is the Supreme Court that will tell us where the line needs to be drawn. For people who are going around in lectures and debates, prescribing people where the line needs to be drawn, it is of no use. Where the line needs to be drawn, the Supreme Court will tell us, and the Supreme Court has given us an answer that the Constitution lays down some reasonable restrictions. We cannot extend or tear the blanket of freedom of expression in such a way that it renders our social conscience and our social values as naked. We cannot let that happen. So there needs, see, it is a very simple example. We have the right to own a vehicle. We have the right to movement. But does that mean we waive away the restrictions of road rules? No, just because we have a right to movement does not mean that we show off the regulation that has been imposed on us by the Motor Vehicles Act. We have to follow the rules of the road when we are driving vehicles on the road. In the same way, we have to follow some rules that have been speculated by the government when we create content on social media and we are using our freedom of speech and expression. We have to follow some rules. And the problem that has been being narrated by people that this is an overreach, this is an undefined scope of law, the answer is a broadcasting bill. The answer is a law that is a very speaking law. So the broadcasting bill or a new law is not a problem, but it is the only solution to such a problem.
But Satyam Surana, it has just been pointed out on this show itself by Apar that you have everything necessary to curb obscene content. The government has showed it has the laws. All the content has been brought down. There are FIRs against, Ranveer Allahbadia, etc. Then why do you need the broadcasting bill?
See, what is necessary, what is presently existing is the criminal course of law. It is a criminal law. When FIRs are filed, there will be an outrage like it is happening right now. We need some parallel mechanism which is a non-criminal or a non-penal mechanism but will still be able to deal with such kind of a menace. That is the need of the hour, where we do not penalize or we do not prosecute or we do not take it to the already existing burden on the criminal judicial machinery in India. But we should have a parallel mechanism that we are able to cleanse the society from such type of filth or garbage that is being produced in the name of freedom of speech and expression.
Okay, Abha Singh, but there is the other side of the argument as well. The other side of the argument is, if you look at this show, India's Got, Latent. Fact is, it was a ticketed show. People paid to be there because they wanted to hear the kind of jokes that Samay Raina cracks. And the jokes, quote unquote jokes, that were cracked by Ranveer Allahbadia are something that have been cracked in India by Indian stand-up comedians before as well. You know, there are clips going viral. My point to you is, in the context of all of this, how do you view what the Supreme Court has said today? Said and done.
See, firstly, in the Indian criminal justice system, you don't have the concept of legal inequality, that you say that negative inequality. There is nothing called negative inequality, that if this actor has said, then why me? If he was not punished, why me? No. Whoever complaint comes and falls within the law, action would be taken, and that is what it has been done, because there were people in Assam who were upset, who felt that it had crossed all boundaries. They went forward, lodged an FIR as per the law of the land, and that is why the FIRs were registered. So this is what the point is. And as I was hearing you saying about the broadcasting bill, I think it would be a Herculean task, because seeing the magnitude of population in this country, the magnitude of people having YouTube accounts, it would not be an easy task. But nonetheless, the law is there. The law defines obscenity. The law defines obscenity and the punishment for it. And I think even AIB roast, in fact, I was the lawyer in that when we got that FIR registered in AIB roast, and the likes of Ranveer Singh, Deepika Padukone, and everyone who was there, Kunal Kamra, I think Aditi, they all were a part of that. And yes, even the actors who were not speaking anything but were laughing at the crass jokes, FIRs were done on them also, because it said that the intention was common. You call it a common intention. Criminal intention means you knew the script, it was a scripted show, and you knew where you had to laugh at the obscenity. So, and in that case also, Bombay High Court put a stay on all the FIRs, and Bombay High Court said no coercive action to be taken, and the case continues to stagnate. But after that, we didn't have any roast of that kind in India. Maybe people got the message. I think today also it's been a long gap, and now with such type of depravity coming on YouTube, Supreme Court has rightly pointed out that this needs to be regulated, maybe if not regulated by a broadcasting bill, but the unsaid words that there is a law of the land, there is 67 of the IT Act, which says that if you transmit obscenity, something which depraves the mind, which impacts the vulnerable mind into a lustful thought, the different definitions of obscenity which is given. First time a punishment is 3 years with 5 lakhs, and second time if you commit the offence, it is 5 years imprisonment with 10 lakhs fine. So the 67 of the IT Act makes things very clear that if you are transmitting obscenity on social media, you said that it was a ticketed show, but what do you think, that it was not taken out and circulated all over? It doesn't. Once it comes in the social media, it is circulated into millions and millions. So Supreme Court today, by making Ranveer Allahbadia surrender his passport, has sent it very clear, okay, we have given you the protection, but you have to follow the law of the land. And by telling him not to put his show, they have said that just for cheap publicity or for your followers, if you are breaking the law, then you bear the consequence.
Okay, Apar Gupta, possibly like Abha Singh is saying, the message has been conveyed loud and clear. But here's the question to ask then. Is this the moment where social media, I'll let you come in, or digital content creators will say, okay, we need to self-regulate? Can that happen? Is it possible? Looking at how vast that universe is. Or will the government say, ye to nahi kar payenge? And ye nahi kar payenge because they have shown us that ye nahi kar pa rahe hain. And Ranveer Allahbadia, and the case with Ranveer Allahbadia and Samay Raina has shown us exactly that these people are not capable of self-regulation, which is why we'll have to step in.
So what is the regulation and what is its ambit is important for the viewers to understand, rather than just the phrase broadcasting bill and regulation. What it contemplated when it was proposed meant that any person who was putting up curated content on any digital platform, and curated was defined very broadly, would require a license from the Ministry of Information Broadcasting on the terms the Ministry of Information Broadcasting decided. So it was basically making every creator, every influencer, every YouTuber into a broadcaster, requiring a license from the government in a way. And this would, of course, be applied in a pick and choose manner, given the number of creators who are there. Now, secondly, there would be licensing conditions. There would be requirements for submissions of audits, of controls for them to have grievance bodies, etc., etc. And this by itself would build a huge censorship apparatus, which is in addition to not only criminal prosecution, but also website blocking, what I already went through before, and it would increase government control. So this is what is being proposed in a way which would lead to a very high amount of government control without any regulatory body directly over content creators. And the outcome would clearly be a very impoverished digital ecosystem in which debate, criticism, and themes which are unpopular, which you do not see on OTT streaming platforms any longer, would be the same on YouTube. Now, Shreya, also answering your question, will creators themselves ask for some kind of regulation and say that the law of obscenity is not clear? All these cases which are being filed against us. I think there is a distinct possibility for that happening, because it will be a plea of clemency that come save us through a law, put in regulation, ask us to take down the videos, but don't call us to the police station. And this has happened in the past, actually, when OTT streaming platforms were facing a lot of writ petitions in high courts, criminal complaints, which was brought to its peak in a controversy surrounding the Amazon Prime series Tandav. We saw only 2 weeks subsequent to it, digital OTT platforms being brought within the purview in 2021 March of the IT rules. And this is why quite often you see a lot of shows which were commissioned earlier no longer releasing. For instance, I can give some examples, but there is enough reporting around this that how we are not seeing certain web series on certain themes in India any longer. And the reason behind that is, again, in the name of regulation, a censorship apparatus was created, giving government control to the Ministry of Information and Broadcasting.
Karan Verma, I can give you the last word on the show. Go ahead, please. You wanted to say something.
So by this logic, Shreya, we would never have a regulatory body. If we start whipping hysteria that it will all be under government control, going by that logic, we would never have any regulatory body regulating anything in any sphere. So, I'll give you one example. In 2015, when the AIB roast thing happened, what the High Court said was, this is vulgar but not obscene. I can bet my last flying buck that, you ask people, what is the difference between the two? Many of the creators, in fact, most of the creators won't be able to answer. So we are bound to have more and more such mistakes in the future. The Supreme Court is not sitting there to implement the law with 80,000 cases pending. We need a regulatory framework so that there is a deterrence, not just criminal prosecution. We need a deterrence. That's how every problem is solved. That's how it's nipped in the bud. So yes, evolving a consensus amongst people and coming up with a regulatory framework so that more such Ranveer Allahbadias don't come to the fore is the need of the hour. We need to be careful that it isn't under the government control completely. I understand that fear and apprehension, but we need a regulatory framework.
Okay, we'll leave it there for the moment. Thank you, everyone. This was a very civilized debate, but it is something we needed to talk about. Thank you very much, Karan Verma, for joining us. Thank you, Apar Gupta. Good to have you on the show. Thank you very much to Satyam Surana as well for joining us. Abha Singh, of course, continues to be with us for the next debate as well. Ladies and gentlemen, I'm slipping into a quick break.